Disclosure forms. I'm a stockbroker, investment advisor, and life insurance, P&C insurance, and a certified financial practitioner. We are a fee and commission-based advisory firm. That's how we're compensated. Lawyers charge money by the hour and by the negotiated price. Is that fair?
Yes.
Okay.
Yes, that's fair.
All right, so we can call Ashley an attorney. We can also call her a professor. So Ashley, let's see if I got this photo for you. Oh, there you go.
There I am.
I stole that from your website. Does that look all right?
Yeah.
Okay. So Ashley and her partner, Kevin Bress, have been in their own law firm for the last few years. She's also graduated University of Baltimore Law School, and she's a professor at Stevenson, right?
Yes, at Stevenson University, I teach 3 classes this semester. So, yes.
Besides running an entire practice, which is she likes to work a lot.
I do.
So she's been working with our clients for at least 5 years as we've been working with Kevin and her prior to COVID. So like you have a marker in life, COVID year, there's pre and post. I'm not sure if we're going to call it PC or BC, something like that. So we've been working before that. So we're going to go ahead and start about things. Now, the one big beautiful bill, what it did was it made some things permanent, some of the law permanent. And one of the things it made permanent is that the federal estate tax is at a $15 million limit. So when you get over $15 million, then there's some federal estate taxes. And then Maryland does not, what's the fancy lawyer word? They don't tie to federal?
Portability?
Yeah, portability.
I'm not sure. Portability, I don't know.
What word I was trying to make up, right?
I'm not sure.
So if you have $15 million of net worth, $5 million is where Maryland will start charging taxes at that time.
They have their own exemption amount, yes.
Right, and so we had some real basic things. Is there an estate tax in Maryland or inheritance tax?
There's both. So if you are personally worth all assets, all in, more than $5 million, then you have an estate tax issue. If you are married and you are on the cusp of just being over $5 million, it is very important that when either you or your spouse passes, whoever passes first, that a portability election is filed so that you can plop your spouse's $5 million on top of yours to get to $10 million and you get rid of that estate tax problem. Inheritance tax is a different type of tax. Inheritance tax, and I'll teach it to you just the way I teach my students, is based off of who you are giving the money to, regardless of whether it's a beneficiary on an account, a joint owner, or if it's passed through a will. So when you go up and down the family tree, okay, those people are exempt. Parents, grandparents, children, grandchildren.
Get all the motions down.
Yeah, get all the motions down, okay?
But if you go wide.
Siblings are exempt.
Okay.
And spouses are exempt. Now, when you go diagonal in the family tree, that's where problems arise, okay? Nieces, nephews, aunts, uncles, cousins, 10% inheritance tax. Outside of the family tree, friends, 10% inheritance tax. The only exception to that, there are 2. One is 501c3 charities. Those entities are exempt, okay? The only asset that you can provide somebody that is non-exempt from inheritance tax is life insurance, okay? So life insurance you can give to your niece or nephew without any inheritance tax being imposed.
Yes, we've actually done that for a lady who has 26 nieces and nephews and cousins, so her tree doesn't go any further straight down. It goes diagonally out, right? Correct. And so we move money to life insurance to provide tax-free, saving the 10% inheritance tax whenever that day comes. All right, so the one big beautiful bill, just a quick summary here, is beginning in 2026 will be the $15 million per person. And that also gives you the ability to do gifting of the $15 million while you're alive. There's no gift taxing in Maryland, but there's a gift tax on federal. But because of this limitation, we can just file forms and give money to the next generation. So if you want to help your kid with a house with $50,000, $100,000, just through filing some federal tax forms, you can avoid that. And with this $15 million limit, that can be an easy way to avoid. That's a very simplistic answer. But generally, we use our accountants and everybody to handle that. All right, so we're going to talk a little bit about probate. And I wanted Ashley to give us a little rundown about the word probate.
Yeah. So the long and the short of it is that a probate asset is an asset owned in the decedent's individual name without a beneficiary designation. Okay. So when someone has an individually owned asset without a beneficiary designation and they pass away, then we will have to open up an estate with the Register of Wills. Now, this is not the same thing as if you own something jointly. If you own something jointly, it's going to go to the other person in most cases. If you have a transfer on death or pay on death, that is going to go to the person on death, okay? You can also have something like a life estate deed that avoids probate where you're basically putting beneficiaries on your home. But, probate documents are all public record. What I mean by that is, let's say that, I pass away, my assets aren't going to be distributed out to the greater, Harford County area. It just means that someone has to pay 50 cents per page online to get that information. Okay. I will tell you, not a lot of people will go online and get that. In my experience, it's only attorneys using that function, but still, it could happen.
Elvis, we like learning about Elvis's estate.
Yeah, we hear about that quite often in the news.
Since Elvis died in 1977, his estate, he had no will. So it's public information. That's why we find out how much his estate makes every year, all the decisions they do at Graceland.
Sure.
It's a fun story.
It is a fun story.
Back to the probate.
So avoiding probate can save money in legal fees, accounting fees, and appraisal fees. However, I will tell you that the number one thing that I want you to really take away from this is it depends on the attorney that you hire, okay? A lot of attorneys will not do something called modified administration. I pride myself in that I have over 70 estates that I manage at any given time, and I would say about 50 to 55 of them are modified administration. And what that means is that it is less legal fees. We do not have to do a down to the penny accounting. It's open and shut within 6 months. A lot of attorneys will not offer you that option because they make less money. Okay, so that's where the probate horror stories come from, is because you have an attorney that wants to do just the full-blown accounting the old school way, whereas I do it in a much abbreviated fashion. We get in, we get out, and we're done. Avoiding probate is a good thing sometimes, and having probate is good as well. If you know that you have a little bit of a contentious family, knowing that maybe your kids don't get along, there is some value to having transparency. And I can tell you that the most problematic cases I have are where mom and dad put beneficiaries on everything, but they're not necessarily honest with the kids about who gets what. And then they start fighting when one person's bucket is bigger than the other, right? So sometimes there is something to be said for having probate, because then it's transparent and everybody's entitled to the information.
Yeah, so probate in Harford County, we go through the Register of Wills. That's where everything's filed. If the person passed away in Maryland, it's the county they're in. They die in Pennsylvania, it's a different story. You have to have a Pennsylvania attorney. You then have to pay Pennsylvania taxes.
Pennsylvania is not a fun state to die domiciled in, meaning where you live, okay? Pennsylvania has a very strict inheritance tax that cannot be avoided even with your spouse, okay? So Pennsylvania is not my favorite thing. I've had a lot of clients that are farmers in particular, where they have land that is half in Pennsylvania and half here, where I've had to deal with that. I don't do Pennsylvania probate, but I have had enough clients give me some feedback about what happens in the Pennsylvania courts, and they are very happy that most of the assets are going through Maryland. So that's just a piece of information for you.
So if you move to Pennsylvania for tax-free retirement, because it is, right when you're feeling bad, you got to move back to Maryland. That's the trick.
Come on back.
Now, Maryland, when you move out, they have a new tax for you. For selling your house and leaving the state. So you got to watch that one. That's part of the Maryland law that happened this summer. Maryland has some extended extra taxes if you make $500,000 too. All right, so we're going to move on to the fun one. Last will and testaments. So my thought is that if we're trying to avoid probate, we have to have instructions for probate. In last will and testament, is that truly telling them what you want done? Is that the best way to put it?
Yes. I mean, you can, it's good to know that a will says what should happen when you pass away, but you can also have trust set up under your will that that you can point at for beneficiary designation so that you don't have to open up probate, right? And so your will is very important in that number one, it says what to do with tangibles, which are the bane of my existence.
Yeah.
Tangibles are always what's fought over. I'm not entirely sure why. And
Is couches or?
I had a case when I was 19 as a paralegal that, oh boy, they were arguing over a tortoise shell.
Yeah.
This tortoise shell was Dad's tortoise shell. And Dad's current wife and Dad's daughter from a previous marriage were fighting over this tortoise shell, and it was worth essentially nothing. I thought about suggesting to my supervising attorney buying one of the parties a tortoise, and maybe this would go away. But they spent about $19,000 in legal fees fighting over a tortoise shell. I've also seen, because I have Derek Hopkins come in and speak to my students. He's the Register of Wills for Hartford County. He's the guy. He has come in and told funny stories about people coming into court and fighting over farm animals that are there. So you really see it all. And, I take pride in what I do with my wills, in that I really explain to the client that, hey, look, we're not going to name specific things in the will, but what you need to do is write a memorandum for special things that would be worthwhile for each person to have.
And then you got to keep it up.
Keep it up.
And sign it, date it whenever you change it.
And so another service that I provide my clients is every 5 years, I send out a letter to my clients saying, hey, has anything changed? Also, have you updated your memo? Did you never do your memo? Maybe you should think about doing your memo, right? So.
All right, and the last will and testament, you name personal representatives or executors, right?
Correct. So you name the person that is essentially going to collect all of your assets and make sure that your wishes are fulfilled.
And how is that different than a power of attorney?
So a will comes into play when you pass away, okay? The power of attorney dies with you, all right? So the financial power of attorney, that has to do with who is making financial decisions for you while you are alive, and that comes in two flavors. The first one is you are so old and gray that you don't feel as though you need to keep your checkbook anymore, okay? So for convenience purposes, you hand it to your daughter or your son or whoever, and they continue to manage your affairs for you. The second flavor is that you are becoming fuzzy or incompetent, okay? And you're starting to not remember to pay bills. You're sending money to people that you wouldn't typically do. And, you need to have somebody safeguarding your money because you're incompetent or you're just no longer able to manage your affairs. So that's what that document is for. And if you don't have one, then the consequences are not great. That is where you will need a guardianship through the court. Those are my least favorite thing to do in my job. I do not like guardianships for a lot of reasons. They are expensive. They take a long time, months, before you even get a hearing to give anybody the authority to pay the bills. There's really not much considered an emergency by the court standards for getting a guardianship, and it's all public record, and your agent or whoever, your guardian who is appointed, has to file a yearly annual accounting with the court and make specific requests from the court every time that they want to be reimbursed or do anything big with the money. So it's very problematic and it's very costly, and it can be completely avoided by having a power of attorney.
All right, so let's say we have a power of attorney. It was written in 2010. It's about 15 years ago. Should we change it?
Well, so the law changed in October of 2010. So if your power of attorney is dated prior to October 1st of 2010, every financial institution has the right to look at that date and say, nope, ain't going to take it. They won't even care about the requirements, okay? So if you fall into that category, absolutely, yes, you should be updating your power of attorney, because I've seen it happen. Now, I say for most people, every 10 to 15 years, you need to meet with an attorney to go over your documents. And the reason being is family dynamics change, people get older. You may not think that someone's capable or the best fit to act as your agent. So it is a good idea to review those things. I can't tell you how many times we've had to use a power of attorney, and the person, the person got their documents done when their kids were born and they appointed their parents and their parents are long gone. Okay, now we're in guardianship land, right? So we need to make sure that we keep those documents up to date, and that's why I send that 5-year letter to each of my clients, and I make it a point that in their review and sign meeting, I say, look, you can ignore however many, you can ignore 2 of these, okay? I think that you're going to be coming back in the 3rd one, or hey, you're at a juncture in your life where I think you're going to need to come back in the 2nd letter that you've received. It just depends on your circumstances.
So the idea is this: everybody needs a power of attorney, no matter what age, your kids, everybody needs a power of attorney for the ability to handle our things during our lifetime. If we're not able to.
Yeah, and with the kids, I will tell you one thing that's very important. I call August my college kid month, right? Because I have a lot of clients, and it also starts to make me feel old because I started out with these clients when their kids were young, and now they're going to college. And it's always cool to hear what they're going to college for and where they're going and things like that. But what people don't understand is when your child turns 18, even if they are on your health insurance, you are not able to get through HIPAA. Okay, they need to sign an advance medical directive appointing you as their healthcare agent in case an accident occurs or they get sick. You're not going to be able to get too far. In that same vein, you're going to need to do a durable financial power of attorney, because what if your child is in the hospital and they're doing everything electronically on their phone, but they can't tell you what the password is. They can't do anything. And children are resilient in most cases, and they do come out, but you do not want them to inadvertently ruin their credit in the meantime. So that's where the financial power of attorney comes in handy.
These are all very important documents to have. We all hate to talk about death, disability, things that are terrible. In financial planning, we want you to handle the worst case scenarios in the beginning of our planning. Getting all our documents, meeting with the attorneys, getting all this put in place so that then we can do all the fun stuff. We can do the investments, we can grow your money, go have your goals, your dreams, change houses, locations, all of that because your documents are already in mind. Now, there's things such as trust. We're not going to tell you from up here that everyone should have a trust. But there's certain fundamental reasons to have trust that are active now. And she had mentioned earlier about trust that can be activated through your will only upon your death. So just a quick overview of what a living trust is.
A living trust is a separate document that is a standalone document where you fund it during your lifetime. You can use it for as much as you want. And then upon your death, it says what happens to the assets in your revocable trust. Now, I will tell you, I'm not a big believer in just selling people things that they don't need. So really, when we're talking about a revocable living trust, I'm looking at a few things. Number one, I'm looking if you have out-of-state property. Okay, if you have out-of-state property and you are wanting to stay a Maryland resident, then yes, I'm going to want to do a revocable trust for you to put your out-of-state property in your Maryland trust to avoid having probate in multiple states. If you are part of a blended family, meaning you are remarried, and you or your spouse have children from a previous marriage, that is a situation for a joint revocable trust, so that no matter which person dies first, that deceased person's children do not potentially lose their inheritance by the surviving spouse changing the will to cut out the deceased person's children. Okay, so we make a joint revocable trust irrevocable, meaning that the terms cannot change upon one spouse's death. So we're locked in 50-50 to each spouse. Okay. Another reason to do revocable living trusts is, if you're really, really intent on avoiding probate, things of that nature, but it is a lot of work on the front end, and it is a more expensive option than what we could probably figure out by just doing a will that has a trust in it.
In Harford County, there's a lot of trust farms that are coming through, doing a lot of seminars, dinner seminars, pushing you into these trusts for $7,000, $9,000, $15,000. My thing is a flag. The flag is why. What's the purpose behind it? Don't get scared into it or drawn into it. Make sure you run it by your financial advisor and the attorneys, get other opinions before you sign on or get pressured into signing into some really high fee by some type of lawyer that does that.
Yeah, and I will tell you, they will sell you that this revocable trust is the end all be all and that it's great. It's never. That's hardly ever the case. It does not offer you any protection. Okay? It does not offer you any liability protection. It does not cut down your taxes. It does not do any of those things. Okay? So that's very important for you to understand.
Yes, revocable living trusts are something where if you think about the business of estate law, being a lawyer, if they raise the federal exemption to $15 million, how many Americans need us to do planning to avoid taxes? Not that many. So they got to come up with other products to sell, other things. So there's gun trust, there's this fear of class action suits against you, and you got to protect your assets. So there's some fear factors on it. So the idea of financial planning is this: know your financial fingerprint, know what you're doing, know your goals, know who you want to receive it. We call that estate flow. Make sure you know what you want to accomplish, and then make sure your legal documents do that. And that's by having an attorney review where you are. And so Ashley's firm, Bress, Stroud Law, what we do is we have them review. Our firm prepares the documents based on the assets you have here, preparing the information form. You have to fill out some questions, who you want to be in charge, and we give that to the attorney in the initial meeting. During the initial meeting, they'll go over and see what you need to do, what changes need to be made, and then you can get the updates that you need. Now, you don't have to use attorneys that we recommend. We can work with other attorneys, but when we work with attorneys, we've done it a number of times. So the idea today was to teach you some basic topics of this, and what I want to do is switch right into my charitable planning one. But I'm going to talk a little too much at first, okay?
That's fine.
All right.
You have the floor.
All right, so I love giving money, your money, to someone else. I love charitable giving, right? Your money, I'm sorry. That's supposed to be a bad joke. All right, so Ashley is going to help me and correct me when I'm wrong, please.
I will do it.
I figured. All right, so we're going to do this. So this little chart is a balanced life of generosity. I believe strongly in giving back first, to tithing, giving to God first. That's from day one, 10% of everything you have while you're alive. Now, when we pass away, I believe you should do it again. You can tithe. If you want to avoid federal government taxes, give it all to charity. You give all your IRAs to charity. No one pays tax on that. Your kids might not be happy with you, but the charities might write you a letter. You won't be there. But there's this life and idea of generosity where we live beyond us, a legacy beyond us, where we fulfill what's really valuable, of whereas using our money to do something far greater than ourselves. At Akers Financial Group, we've helped many people fulfill their goals and dreams by creating these charitable gift plans. So I want to go through some ideas. Now, this is a great sunflower photo. I don't think it's real. I think it's fake. When you have a desire to leave money to a charity, that begins in your heart. Whoa, begins in the microphone. Then what happens is we can then affect it to your financial plan and tell you where is the best place to do it. And that's what we're trying to cover. All right, so make sure the charity you name is a qualified charity. The qualified charity, the IRS actually has what a qualified charity is. The word qualified, if they're not, then they're probably your kid. They're not a qualified charity. But qualified charity, you can give to them and avoid taxation. IRS.gov happens to have that. All right, should you leave your retirement assets or should you leave other assets to charity? Retirement assets are going to be taxable to someone at some point in time. If you pass away and give them to your kids, this new law came out about 2020 called Secure Act. Secure Act, instead of allowing your kids to take it out over their lifetime, they shrunk it to 10 years. And they have 10 years to take the money out. We've had a great decade of the market moving up, and that great growth in the market has made clients multiple millionaires in tax-deferred retirement. And now we have high RMDs, and we have high taxation to kids later when they receive the money. So if you look at this chart, you'll see at your death, retirement assets do not get a step-up in basis. They're subject to both income tax and estate tax. So higher taxes are, like in Maryland, above $5 million, there'll be some Maryland tax of 16% and income tax. Other assets do get a step-up basis. That's like a house and stock accounts. Step-up basis means you bought the house at $100,000 and you give it to your kids upon death, not while you're alive, and your house worth $500,000. The full step-up basis means if they sell it right away, their cost basis is the date of death value, $500,000.
Correct.
So life estate deed does that, right?
Correct.
How about someone comes in and goes, I just added my name to mom's house.
Not good.
That's terrible, right?
Terrible idea. And here's why.
Go ahead.
Because you get the basis of what the value was when your name was added. And then you have liability problems that I won't get into, but that's never a good idea that I like to see. Okay, you should be doing it through what's called a life estate. But you should know that I typically don't even recommend that sometimes because, I'm an only child. It would be very easy for me to have a life estate deed to myself on my parents' house because who else is getting the house? It's just me, okay? But I value the protection of receiving my inheritance in a trust under my parents' will that protects me if I were to get divorced or if I were to be sued by a nutty client or bankruptcy or anything like that. It's protected. So you have to weigh the pros and cons while making this analysis, and this is where a lawyer is helpful.
Now, in the first session, we talked about a herd of cash cows to live off of your money. By having money diversified, you then can say, oh, my Roth IRAs, my personal assets, my real estate, all going to go to my family, but my retirement, I want to give to charity. I want to avoid all that deferred tax. And that's a great idea. We just have to make the beneficiaries the charity themselves. And so as we go through some slides here, if I can get, there you go. There are some ways of doing that. We can do that while we're alive. Now, on this chart, I should have updated it a little bit better. There's this idea that a qualified charitable distribution, you can actually give $105,000 in 2025 personally to a charity instead of like your RMD where you pull money out and pay tax. You can just give it to charity. With the standard deductions being like $31,000 in retirement, it's hard to have enough charity. Under the One Big Beautiful Bill, the SALT deduction, state and local income tax, is allowing us to not have a limit at $10,000, but up to $40,000 within income limits of under $400,000. That SALT deduction and your charity, you're going to have to get all your information this year to look at your itemized deductions to see if it makes sense to itemize or not. I think QCDs make a lot of sense, and then you have the standard deduction, but you got to evaluate if you own 2 properties and what other deductions you're trying to take as an itemized person. So understand qualified charitable distributions. We do a lot of these. At Charles Schwab, once we set up the account, we have it set up with a paperwork by our operations department. You call in and say, hey, give my church $2,000, and we can send it directly without any more signatures. So there's a real convenient way of doing this. The new rule this year, your qualified charitable distribution will be listed on your 1099-R, saying that that was actually happened. Before, you had to prove it yourself. It was all subject to whatever you could prove. Now it's going to be on the reporting document, hopefully. I say hopefully because I don't trust it actually happening. All right, if you leave your retirement assets to charity, do not do a Roth conversion. So what that means is this. Roth converting is paying tax now, never again. I like that. I like to allow the money to grow. Roth IRAs are one of the best things, besides life insurance, to give to your kids. A Roth IRA still has a 10-year rule. There's no annual withdrawal, but it's tax-free. And I love tax-free. How much taxes do you pay on tax-free, Joe? You know? Nothing, right? Yeah. Good answer, Teresa. So the idea is this. Tax-free is nothing. Your kids pay nothing on it. Life insurance is fun. Well, not fun for those that passed away, but those that receive it, and that the check comes within a couple of weeks, and it's all your check. There is no taxes, nothing extra. All right, so I'm not excited about death. I'm trying to explain the financial side. Moving right along. Life insurance is a way to fund charitable bequests. Now, life insurance, you can fund that and give the life insurance to the church or whatever. I'm not the biggest fan of it. I'd rather the life insurance fund the family. So like if you say, hey, we're worth $5 million, I want $5 million to go to my family, but I still want money to go to charity. So what I can do is I can have the IRAs go to charity. I can use cash flow to fund life insurance to have a wealth replacement trust to build up the money for the family back to $5 million. So there's all kinds of ways. In that kind of concept, the only person we cut out is the IRS. So I love that. We've done that a few times for people. I've had a few favorite clients that one guy came in and says, I want to give my money away. He had about $3 million. And we just kept giving money away as he was in his 80s and his wife passed away, kept giving more money away. We calculated how much he needed for the rest of his life and gave the rest away. We ended up giving off $3.5 million away, and his family still got $1 million because of other planning we did. It's pretty cool. Wealth replacement trust, is that just like your revocable life insurance trust?
Yes, yes.
Are they difficult?
No, they're not difficult. I mean, the only thing is that you're going to need to do crummy letters, which you can't be trustee of your own irrevocable life insurance trust. Typically, you pick your attorney to do it, and once a year or twice a year, depending on how many times you pay the premium, you issue a crummy letter, and that's it.
Yes, crummy letters. It was based on a life insurance case for an ice cream company, and it has to be a family called the Crummies. So it's a pretty fun case if you ever want to have fun reading about it. Should you name both individuals and charity as beneficiary of the same retirement or split the plan? Now, the reality of the law in Secure Act, if you have a beneficiary, 20% to a charity, so much to your spouse, so much to your kids, you create a problem on the 10-year rule. There's been different findings. I go to Ed Slott for Master Elite IRA conferences, like 16 to 32 hours a year, just on the design of beneficiaries. Our advice is charity should be a separate account, IRA going to charity, your spouse gets an account, and kids will get another account. Because you got to make sure the spouse can pull the whole account to their name without filing a special 301, I think that code is. And then the kids can do their 10-year draw over time. Now, the 10-year draw for kids can be done through trust.
Yes, it can.
And why would someone want to do that?
Because as you're pulling out of the IRA, you are basically transferring it to a brokerage account to be invested instead of giving it directly to your children, so that the funds are protected from divorce, bankruptcy, suing, anything like that. And the kid can be their own trustee, but you just need to recognize that they can take as much or as little as that they want, but they do have the power to blow it up. So it should be explained to them that they should use that as a nest egg that builds over time, so that that is protected money.
Right, they still pay tax on it, but you could be able to control beyond the grave by the way of using a trust that has the qualified ability to take the distribution. It's a little more complex, more if you are concerned about your child or their spouse. It might be a good signal that you need to do something special. All right, do not name your estate as a beneficiary. Now, let's use retirement plan first. They say estate. I say no, because that basically avoids a 10-year rule. You have to pay tax all at once.
Yeah, that's never a good thing to do. I've had to write many letters to many different financial institutions, because there is a private letter ruling that says if someone inadvertently put their estate as the beneficiary, I am able in some cases to get it to go directly to their children or their spouse instead of the estate. But it is very hard, and it's time consuming, it's expensive. You don't want to take that hit on the chin right away. You just don't want to do that.
Yeah, so the slide is actually going over the concept. If you have your IRA go to the estate, and then the will then sends it to the charity, you pay income tax, and then you get a deduction. You don't really get the full bang for your dollars. So earlier I was talking about estate flow. Who do you want to receive the money? When do you want to get it? That's the important thing in planning, is laying this all out so that it can go to where you want it to go. We hope that you have a heart for giving, and that heart for giving, we can then take your financial fingerprint, where your money is, and design the right paths to get that money to where you want it to go. All right, as we consider this, I'm skipping this page because this is like me diving way too deep into charitable trust funding. But the idea is that you can have your own charitable trust. You can have things that can really provide for your family. There's charitable trust where you can put money in. You can sell a highly appreciated asset, then they'll pay your family money for as long as you live. When your family passes away, it goes to charity. And that's usually done if you have really high amounts of real estate or a certain type of stock. Keep family beneficiaries informed and charitable intentions. Make sure you have your personal representative, your executor, your power of attorney know where the documents are. They need to know what your wishes are. As financial advisors, we want a copy of it all so that we know that the planning we're doing is what you want, what you wrote down. So we review with you what you wrote down and what you have in your document. Actually, it was all working together. Now, over the years, we've been talking a lot about beneficiaries, making sure we set up a primary beneficiary, but it's also very important to have a contingent beneficiary. Contingent, can you explain that a little bit?
Contingent is your backup beneficiary. And so, it's very important to have a primary, obviously, but it's even more so important that we keep an eye on the contingent beneficiaries, because what I see a lot is people are married a long time, and when one spouse goes, the other one is not too far behind. So if you don't have a contingent and you don't have any reason to think about putting a contingent, then, your asset is going to go to your estate.
Contingents, if your primary doesn't want the money, they can actually disclaim it, and it goes to the contingent, to the next one. And that might be important. There are lots of reasons, but generally I had this one case where basically the person had their mother, and the mother didn't want the money, wanted to go to the grandkids. So they pushed it down to the grandkids. So in this kind of case, the contingent gives you the ability to actually, the beneficiary, to disclaim something and not receive it, which is just a little option we have. QCDs, you covered earlier, it is $105,000 per year. You can give whatever amount you like. We calculate your RMD into January every year based on the IRA's value at the end of the previous year. We do that for all of our clients' money at Akers Financial Group. And then we start the planning of withdrawals throughout your year. If you want to give to charity, it's really great to be able to give it straight out of the IRA. The new tax law, the OBB, One Big Beautiful Bill Act, July 4th, 2025, actually gives us a charitable deduction as a straight line deduction this year. So up to $2,000. Paul, is that for two people? $1,000 per person? You can take off a charity off of your tax return. That's a new thing. So keep track of your charities this year. Pretend like you're itemizing again. It's just a different year for that. All right, so we're just going to buzz through this a little bit. The QCD is where your IRA, it becomes like a checkbook for you. In other words, the IRA is giving to your charity. Some people like to give the church every week, and they give it, and then they can't deduct it off their tax returns. They didn't have enough. So we have to tell people, stop giving every week. Let's give the money out of the IRA, and we have the IRA send it to you, and then you turn that into church. Now, you don't have to feel guilty if you don't put in the offering plate every week, even if the usher puts it in your face too much. You could say, I'm digital, I pay online, or you pay at home, or they don't never understand if you said QCD. But if you want to mess with the ushers, you can do that. The QCD, Qualified Charitable Distribution, once you're 70 and a half, it makes sense to begin doing it. Once you're at RMD age, which is 73 or 75, really makes sense if you are a charitable giver. So that's why I recommend that. The QCD to a charity where the IRA owner has an outstanding pledge is not prohibited. So if you say, I promise University of Maryland $10,000 a year, you can give $10,000 a year out of your IRA to that. It's not a problem. You can't give to anything such as a donor advised fund, something like that. Now, people over the years have used to do private foundations. Private foundations is where I think you need $250,000 before you do something like this. This is where you can give money to a charity that you control, maybe with your family, and you can set a purpose in mind. You hire CPAs, accountants, and you put it all together, and then each year you file your tax returns to make sure you do it right. The private foundation is a great way for your family to build wealth inside a foundation and give together on an annual basis. Now, what I want to do as we close out here is thank Ashley for your time on stage. Appreciate it.
Thank you for having me.
Thanks very much, Ashley. He's going to talk a little bit about donor advised funds as we finish up this hour. Donor advised funds are going to be a way that we at Akers Financial Group recommend if you want to put money into something where you want to give over time. And so we're going to try to explain that. So Nick, we welcome you to Akers Financial Group. Have you had fun with us so far? Yeah, turn it on. One more time.
One more time. Hello. Thank you so much. Yes, I've had a great time.
Great time. Well,
absolutely.
You've been through the torture of Akers Financial Group?
I have been through the gauntlet.
Yeah.
It's been enjoyable, though. Very educational. Great place to work.
Now, Nick's worked with banks as a financial advisor at banks, worked at TIA CREF, and now he's dropping into an independent financial advisory firm at Akers. He's from Bel Air?
That's correct. Well, I was born in Cockeysville, but I spent the better half of the past 38 years in Harford County.
Right. He's not 38, though.
Yeah, 40. Moved here when I was 2.
Yeah. All right. But Nick, Most of my advisors, I built the teams, advisor at Akers Financial Group, have all been my assistants before. And so they spend years in the trenches learning everything, and then they become an advisor. So Nick, through, I don't know how many months we talked about you coming, at least 6 months or more.
It was a good 6.
And where we finally got to a situation where I really believe he's going to be a great fit at Akers Financial Group and for our clients. And so we do welcome Nick. And so I gave him one of the first jobs was to figure out donor advised funds, which company to go with. So what we want to do is cover this for a few minutes. So explain the basics of a donor advised fund, please.
Yeah, absolutely. And just to touch a little bit more on what Brian was saying, about my personal career, a personal goal of mine was always to give back to my community. Growing up in Hartford County, I really was looking for an opportunity to be somewhere where I can work with my community and give back in some way. So working with everyone in Hartford County and in and around the area has just been wonderful. So I look forward to a long, successful career at Akers Financial, and It's been great.
You signed a lifetime contract.
It was a pretty thick
Did you read
packet.
that part?
I didn't. I glazed over it. But no, Brian gave me the opportunity to look into the donor advised fund. I do believe that the philanthropic opportunity to give back and charitable giving is very important. A lot of clients, especially in my experience, are looking for multiple ways to be able to give back. And Brian touched on the QCDs, which are very important. But donor advised fund, it's more so of a way to give your after-tax dollars, to leave a legacy, and to be able to decide how and when you want that money to be distributed to the charity of your choice. So to simply put, a donor advised fund is basically a charitable investment account. When you make your donation, it's immediately tax deductible. And then you have the opportunity to grow those assets tax deferred. And then at the time of your choosing, you can make individual grants to the charities that you choose as well. Through Franklin Templeton, we can offer advisors and through us as well to help you navigate which charity you would like to make that donation. But really, it's a way to make your donation and get your tax deduction immediately, and then invest that money. And while it's sitting there, it's growing tax deferred. And then you have the opportunity to then decide on that 501c3 or that charitable organization to which you would like to make your donations and continue that ongoing throughout the rest of your life, and then continuing on through your legacy, whatever your legacy plan may be. You can identify individuals you can actually continue on with those grants to those specific charities of your choice.
Yeah, so an example that I really like is I wanted to put money aside, and I want money aside where my whole family can learn to give and actually talk about giving money out of that fund. And so I call it the LAVA, Christian Service Ministry Fund. And so I was in this Franklin Fund, you can label whatever you like. And by labeling it, it's not really a true foundation, but you're labeling it a name. I call mine LAVA. It's named after my grandmother. So the idea of the LAVA Fund is to give out a portion of the money every year. So if there's $10,000 in there and I want to give 5%, that's like $500 a year. Then our family's had a couple of votes over the years where we give $125 at different places. We've done that a couple times. And so the idea here is, as we build an account at Franklin, yes, there's charges for us to invest the money for you, but that money is $5,000 a minimum. $1,000 is a deposit minimum after it's set up. When the money goes, it's gone. I can't give it back to you. It can go to charity. You can close out the account anytime you like. The account is set up, and you have your donors, and then you set up a lot of other people, right? The grantors, things like that.
Oh, you can have grantors. You can have successor grantors as well, as I touched on earlier. So if someone wanted to step in and take over for you and continue on those grants, you can assign them as well.
We might have a handout about this. If we don't have it in here, we'll have it out at the table. The table is a question and answer table where our advisors are there able to help you. We have a brochure that's heavier. This is a brochure. This is a Franklin Fund, a full explanation, 54-pager. We only have 10 of those. 32. We can give you the QR code for the website if you don't want paper, which is more fun.
Yeah, it's right outside the door. So if you felt like grabbing one, it gives more information about how you can set this up. The actual application is inside of this brochure as well. It talks about the multiple fund or the multiple investments as well that you can choose from. So depending on whether or not you wanted to use stocks or global, domestic, there's multiple different options as well. So it can fit your charitable risk tolerance as well. So
and your minimum grant's $50. So you got to give a little bit more than 50. So this could be any charity that you like. So the charities have to be through the IRS and have to be basically churches are already assumed to be a nonprofit. Religious and educational, most established religious, unless they're on a list where they're told they're not allowed.
I think the key is that, again, it has to be a registered 501c3. So it can't just be, someone that you wanted to give money to. It has to be registered under that tax code.
Like it might be a missionary or a pastor, but you'd have to give it to their church to be able to do something like that. You have to give it to the charity, not to a person. All right, so donor advised fund, we want to introduce that this year as a concept, as an idea. That might not fit for your situation, that's perfectly okay. If you're giving to your church and you're fine with them having all the money and going, it's fine. If you want to build an account that grows and that will have money that can continuously give is a very good thing. Now, what happens if someone passes away with the donor advised fund?
So it can continue on with your legacy. Again, you can identify or name successors, and one of the other themes as well is if you did not have a specific charity, but you had a theme, whether that be cancer research or Salvation Army, they can carry on those grants as well. Right, so people step in and take over for you.
So in that example, let's say you name St. Jude as the big finishing charity. When all your family is not around, all of it would go to to them, and then they were able to handle that donation at that time.
And actually, almost like a trust will dictate how you want assets to be passed upon your passing. You can identify a certain percentage of your assets. Say you would like 4% of the fund to be donated every single year, so it can continue to grow based on your investment allocations, and then a portion of that is just continued on as well.
Yep, absolutely. So donor advised funds, an idea we want to cover today. In this topic, this hour, we've been covering estate planning, legacy, charitable giving, just a little bit of topics. The idea at Akers Financial Group is we love to help you do what you want. Your estate flow, your charitable heart, whatever your wishes are, we want to make sure we can make that happen through planning with all of our team of advisors. Now, next year, when we're doing this again, September 11th, our goal is to have a big financial forum where we're hitting the current topics of the day. A little bit like we're doing this year. This is our trial to see if you guys like it this way, where we're going to be moving with topics, not diving as deep. Our classroom at our office, we're going to do more deeper in the topics on RMD, how you calculate it, all those fun things. But on our big training day, we're going to switch more to like a financial forum where we're truly delivering information as fast as we can. See you in a few minutes. Thank you very much.